Buenos días a todos. No voy a tomar más que 3 segundos. No están acá para escucharme a mí. Yo les agradezco a todos el que hayan venido. Entiendo que esto para todos, y me incluyo, es un gran placer y no una obligación. Solamente desde lo institucional, congratular a todos aquellos que han logrado de que este viaje de Ronald Dworkin se hiciera realidad a la Facultad de Derecho, que el honoris causa saliera, porque básicamente la reunión de ayer y la de hoy son una gran demostración de que el conocimiento no tiene límites, de que el conocimiento habilita la libertad y de que el conocimiento es un placer. Para esto sirve la Universidad Pública Argentina y yo realmente estoy absolutamente complacida de poder ser, como todos ustedes, un partícipe más de esta actividad que promueve el conocimiento, que promueve la libertad, que promueve las fronteras de todos nosotros para pensar el derecho, que en definitiva es la pauta de conducta de todos nosotros. Muchísimas gracias. Los dejo con Roberto Gargarella, que va a hacer una pequeña presentación, y luego con el profesor Dworkin.
Bueno, buenos días. Dos apuntes formales y después alguna mínima introducción sobre el libro. La idea, en parte en conversación con el profesor Dworkin, es que él va a hacer una presentación muy breve, de 15-20 minutos, para que tengamos el máximo tiempo posible de discusión, y él inclusive pidió extender el tiempo de discusión, así que creo que vamos a tener las posibilidades de debatir extensamente, y eso creo que también es una muestra del compromiso académico indeclinable de Dworkin. Sobre las preguntas, él lo que sugería es que sugeríamos también nosotros, la gente que puede hacer la pregunta en inglés, es mejor si la hace en inglés, pero obviamente si alguien la prefiere hacer en castellano, puede hacerlo. Voy a coordinar las preguntas y les voy a pedir que sean muy breves con eso. Y creo que nada más. ¿Cómo? Sí, que el profesor Dworkin también sugirió que si alguno quería hacer preguntas más allá del libro referidas a la conferencia de ayer, también están bienvenidas. Nada más decir que el libro, Justicia para erizos, es el producto de una vida de reflexión crítica, reflexión contra la corriente, reflexión contra el saber establecido y el producto de permanentes debates, muchos de los cuales han trascendido y siguen siendo hoy y van a seguir siendo marca en la vida académica de nuestro tiempo. El libro es producto de los debates de Dworkin sobre la cuestión de los derechos contra el utilitarismo, los debates de Dworkin sobre el positivismo y sobre la discreción judicial con Hart. Es un producto de los debates del profesor Dworkin con el conservadurismo en defensa de una cierta lectura del principio de igualdad. Es producto de sus discusiones con Rawls sobre teoría de la justicia, con Rawls sobre la relación entre la ética personal y la moralidad política, producto de sus debates con la academia jurídica, con jueces como Antonin Scalia sobre interpretación constitucional y originalismo, debates con muy de nuestros días, de estos días, con autores como Jeremy Waldron sobre democracia y revisión judicial, pero también debates sobre el aborto con las posiciones más fuertemente religiosas, sobre affirmative action, con acciones afirmativas, con la Corte Suprema, sobre el derecho a la pornografía, con McKinnon, sobre política y dinero, contra fallos como Buckley. Es una vida dedicada a la reflexión crítica entonces y a los debates. En este libro, además, yo creo que él trata de hacer algo más que meramente resumir 50 años de reflexión académica. Algunos grandes filósofos políticos, morales contemporáneos, como como Amartya Sen, por ejemplo, han escrito grandes obras recientes como Una idea de la justicia, en donde lo que yo creo es que lo que hacen, y es extraordinario, es resumir toda una vida de reflexiones. Dworkin en este libro creo que hace algo que va bastante más allá, porque por un lado, y este es un desafío extraordinario, trata de mostrar que todos estos debates, todas estas cuestiones forman parte, son diferentes aspectos de la misma pregunta. O sea, poner en la misma línea de reflexión, en la misma línea de pensamiento crítico, todos esos debates, digamos, pueden mostrarse que son consistentes unos con otros y responden a una misma pregunta. Y va más allá de eso porque, como uno dice, hace el intento de tirar todos esos hilos juntos y mostrar la continuidad de ellos, la vinculación entre ellos y la posibilidad de ir más allá. O sea que es un intento de ir más allá, de tirar todos esos hilos juntos más allá luego de 50 años de reflexión académica. El producto es un libro muy complejo, que es al mismo tiempo legible, pero a la vez muy complicado. Cuando Jerry Cohen hizo una review sobre el libro de Dworkin sobre la virtud soberana, sobre igualdad, decía que había que leer ese libro acompañado con varias tazas de café, varias jarras de café. Yo creo que este libro requiere varias jarras de café y varios, no sé, dry martinis para poder llevar adelante esa empresa. Y lo peor de todo, en parte por tener más tiempo para discusión y en parte por una pequeña revancha, le vamos a pedir aquí entonces que resuma 50 años, ¿no?, de vida académica en 20 minutos, así como una pequeña revancha, todo lo que ha hecho. Bueno, muchas gracias, profesor.
Can you tell me if I'm audible? Are the translators able to hear me?
Yeah.
Translator say something? Okay. I'd like to add on to my 15 minutes, a few minutes, to speak about Carlos Nino, because as I understand it, this is a meeting in his honor. I met him when I came to Argentina with some other philosophers, I think at an invitation arranged by Carlos, and I found him the most extraordinary man, to be so gifted and prolific and original in legal philosophy and moral philosophy, really prolific and extremely interesting, and at the same time to be so committed to the achievement of democracy in this country, unflagging dedication. And I had nothing but admiration for him. And when I heard of his sadly, ridiculously early death, I was saddened. And when I arrived here 3 days ago, I was saddened again because he was not here. But the memory that I would like to share with you is about a different quality. It's about courage. When I was here all those years ago, Carlos invited me to his house for a drink and a meal. We drove up to his house in his car, and when we got out, he pointed across the street, and there was a rather frightening-looking Ford Falcon. I didn't even know what a Ford Falcon was, but he showed it to me. Looked like an ordinary, not very attractive American car. And he said, that has history attached to it. And then someone got out of the car when we arrived, and we were crossing the street to go to his house. Someone got out of the car, opened the boot or trunk of the car, and took out a rifle and held it up practically in his face, and put the rifle back into the car. And Carlos said to me, that's meant to frighten me, but it doesn't. And I very much admired that moment. I'm going to try to summarize this rather large book. The book, I think, is an illustration of a style of doing philosophy, which I wrote about some time ago. I called it an inside-out rather than an outside-in method of philosophy. That is, I started my career after I finished being a lawyer. That didn't take long. I started my career with a central interest in human rights and political philosophy. And I thought that it would be necessary to concentrate and not deal with very abstract philosophical issues, but to concentrate on the practical issues. I wanted to write articles in what we call popular journals, though the New York Review is perhaps not quite a popular journal. It still has a very wide circulation. But as I began to work on these issues academically, I soon discovered that you couldn't avoid the abstract issues because the difficulties that you encountered thinking about what ought to be done about abortion, what ought to be done about abortion or affirmative action. If, as soon as you began to reflect about these, you saw the importance, the crucial foci of philosophical issues bearing on what you took first to be a very practical issue. And that's what happened in the writing of this book. I wanted finally to go in the other direction. I wanted finally to say, now I've thought about all these issues, now I'm going to try and present a philosophical position, and then at the end point out the political implications of that philosophical position. It's true that a great deal of this book is an attempt to synthesize what I had studied in this inside-out way for a long time. But in writing the book, I found that even more reflection on mainstream general philosophical issues was necessary, and so a good part of this book is my first attempt. In this summary, I'm going to try and emphasize that process and emphasize the general philosophical issues that might not seem at first sight connected to questions, practical questions of politics, but which, in my view, turn out to be very central. The book has 5 parts, and I'll just mention what I take to be the most important, and in some cases, the newest of the theses that I wanted to defend. The first part I take to be extremely crucial. It's directed against skepticism. I want to reject the idea that in morality and politics and ethics, skepticism is the natural or default position. Many philosophers have argued against moral positions, against moral claims, by saying moral claims can't be true or false. They just represent our feelings, our own subjective reaction, and that is demonstrated by the fact that people disagree about moral issues. They can't prove one position or the other. People who believe one thing can't convince the other person. And therefore, morality is not an objective matter. The mistake, I believe, or so I argue in the first part, the mistake is not to realize that skepticism is itself a moral position. If I say employers owe medical care to their employees, and someone else says, nonsense, that's just your opinion, you can't prove that, I want to reply, well, I see you have a different opinion. Your opinion is that employers do not owe health care to their employees, and that is as much a moral opinion as the opinion that I set out. And if you argue against my opinion by saying, well, people disagree, I will reply, yes, and people disagree about your moral position. For example, I disagree with it. It's very important, I think, to establish that there is no such thing as a morally neutral kind of skepticism. There is a discipline, philosophers like to say, we study meta-ethics, and we draw our conclusions about subjectivism and skepticism from an independent philosophical meta-ethical position. In the first part of the book, I argue that that's terminally confused, one confusion after another. In the second part of the book, I take up the question of how we should think about moral issues. And I argue that there's a kind of intellectual activity which we ought to recognize as interpretation in general. Interpretation is different from explanation. I try and illustrate the difference in part 2 by talking about interpretation in art. I consider, for example, what would make one interpretation of a very complex poem by, for example, Yeats better, sounder, more accurate than another interpretation. I won't try and summarize the theory now, it's rather complex. But I offer that general account because I want to introduce another idea. First, that the analysis of moral concepts, justice, liberty, law, is interpretation. These concepts, the root concepts through which we conduct our political reflection and our political debates, are interpretive concepts. We can't analyze them in some neutral way, by distinguishing between what the concept means, just as a matter of semantics, and what the truth is, what the concept of justice is, or the concept of law is, on the one hand, and on the other hand, which institutions are just, how judges should decide cases. There isn't any such distinction. A theory of what the concept means is a substantive moral theory. In this section of the book, I also make a claim which is, it would be an understatement to say controversial. And the statement is that the leading philosophical concepts, including the concept of truth, are also interpretive concepts. A theory of truth is a moral theory about when we ought to react to evidence in a certain way. So the second part of the book makes a very broad claim. It's a claim that that I found required, again, by starting with very practical issues and just seeing how the correct approach to these issues required a study of the most abstract philosophical issues, those that might at first sight seem furthest from ethics and morality. In the next part of the book, I take up ethics. I have, for a long time, following Bernard Williams, who introduced the terminology, I have distinguished between questions of ethics, by which I mean questions about how to lead a successful life, from questions of morality, which are questions about what we owe to other people. I begin with ethics, and Marcelo summarized this very eloquently yesterday. I begin with ethics and with the idea of dignity. To me, dignity has two aspects. The first part of dignity is a sense of self-respect, that your dignity requires that you think it important that you make some success of your life, not because you happen to want to make a success, but the other way around. You recognize you want to lead a successful life because you recognize a cosmic responsibility to do that. I can't prove that to you. I think it's a good interpretation of how at least most of you lead your lives, though it might sound unfamiliar to you. The second part of dignity is this: one person has got to assume responsibility for each life, and that is the person whose life it is. I suggest in that part and in the rest of the book that we ought to approach the interpretation of concepts of morality and concepts of political morality as asking for the solution to simultaneous equations, to find some interpretation of what we owe others by way of aid, of when we harm others, of when we have obligations, of what political rights are, of what liberty is, equality, and law. We ought to seek an interpretation of each of these ideas that respects both parts of dignity, both parts which at first sight seem to pull in opposite directions. It seems that the first principle of dignity, that everyone's life is of intrinsic importance, pushes us towards equality as a political ideal. But it seems that the second principle of dignity, which requires people to take individual responsibility for their own lives, resisting any attempt by government to hold them, to usurp that responsibility, that seems to push in the direction of liberty. Therefore, the correct account, in my view, of liberty and equality must be one that shows the two virtues not only compatible, but each drawn from the other, because only in that way could we achieve solutions to the problem, the conceptual problem, that fully respect individual dignity. Most of the latter part of the book is an attempt to produce theories of all of these concepts: justice, liberty, democracy, law, justice, an attempt to produce conceptions of these which solve the simultaneous equations of dignity, truly respect the dignity of people one by one, and that also serve as good interpretations of our political practice. How far I succeed in this can luckily only be judged by you once you have read the book. Thank you.
Vamos a abrir entonces un tiempo de preguntas, que les insisto que sean breves. Así que si alguien quiere preguntar, levanta la mano. Paola. Bueno, profesor Bulli.
I would like to ask you a question. In more than one occasion, you insisted that the law probably integrated with moral principles and so on and subject to best light interpretation, always has an answer, a right answer to every question and to every legal problem. Does this idea mean that law with principles and so on is always complete and consistent? That there are no situations when the law is silent, doesn't give any answer. There are no situations when the law gives more than one answer. This is my question.
You state my conclusion, and I take it that your question is, how could anyone possibly believe that? Now, I don't think I've ever said that in every case there is a right answer. And if you include the possibility of the law being in conflict on some issue, then I have to say I don't rule out the case. We encounter it in mathematics, for example, where there really are right answers. I don't rule out the case where the right answer is there's a conflict, there's a contradiction. I don't think that can often be the case. Indeed, I've never encountered that. I don't know anyone else who has either. If you think about the solution to a legal problem as the best interpretation of the legal material, the best account of what the political community has done by way of legislation, what it's done by way of precedent, what the Constitution says, what the history of the Constitution has been. If you understand that what is required of you is the best interpretation of all of that material, then the idea that there wouldn't be a best interpretation becomes very strange. The appeal of the idea, it's a very popular idea, that no, sometimes there's no right answer, we just have to acknowledge the law is silent on the subject. The appeal of that idea, I think, comes from what I described as a fallacy, in what I attempted to identify as a fallacy in the first part of the book. And that is that skepticism, which says, no, there isn't really one right answer, is the default position. That is the position that you fall back on if no other argument seems compelling to everyone. And that's, of course, the history of legal philosophy is full of that. People say, oh, well, some lawyers think this, some lawyers think that. Therefore, there's no right answer. Very puzzling confusion, I think. No, it doesn't mean that, because that there is your view that in some cases there is no right answer is itself a theory, which is an interpretation of all the vast legal material. And that interpretation is as much candidate to be the best interpretation and is as subject to the objection, well, people don't agree, as any more positive theory of what the right answer is. We're all in the same boat. The one, I think, reason why my view might seem so paradoxical is a failure to distinguish between two important ideas. One is uncertainty, and the other is indeterminacy. Indeterminacy is the view that there isn't any right answer. Uncertainty is the view, I don't know what the right answer is. I don't even know whether there is a right answer. Uncertainty is the real default position. You think and think and think, and you decide, honestly, I can't see any daylight between the two rival readings of the law. If I can't see any daylight, I should announce that I'm uncertain what the right answer is. But if I go on to say there is no right answer, I'm no longer resting on uncertainty. I am saying I know the best interpretation of the legal material. I have resolved the issue in my own mind. The best interpretation produces conflict or produces gaps in the law or produces silence on particular questions. You need an argument. You need an argument as to why that's the best interpretation. Given the enormous amount of material available for a legal interpretation, I find it very implausible that that would be the best interpretation. If you have only a very small amount of data, perhaps, but if you have a century of legislation, precedent, administrative agency, rulings, I find it extremely improbable that you could make a case that would say the best interpretation is some kind of a tie. Now, I know that doesn't convince you because you and I have discussed this question before, but that's the best I can do.
Professor Farrell?
Professor Dworkin, you wrote in your book, and you talk again today, against moral skepticism. But explicitly in your book, you accept the two main tenets of moral skepticism. First, there is no truth by correspondence in morality. And secondly, the truth by coherence is a necessary condition, but not a sufficient one. Of course, you employ the word truth in your book, and you have every right to do it, but you use truth in a very different sense. A proposition is true when it is supported by the best arguments or the most reasonable arguments. But this is not the sense of true meant by skepticism. So I am a moral skeptical and have no quarrel with your position. It seems to me that you're employing the sense with another meaning, and you're not refuting moral skepticism, but your tenet is perfectly compatible with it.
Thank you. Very interesting, very interesting suggestion. As I said in my summary, I think an actually quite central crucial part of my overall argument is a theory of truth. And I have a chapter, or part of a chapter, in which I argue that truth is an interpretive concept. The coherence theory of truth, which you mentioned, the correspondence theory of truth, which you mentioned, are two interpretations of the idea we use very freely. Somebody says affirmative action is unfair, and another person says that's not true. And we understand exactly what's happening. So the question is, how are we to understand what truth actually means in these cases? In the case of science, it's a very popular view that we understand truth when we say a proposition is true if it matches reality, if it corresponds to reality. Nobody has ever been able, in spite of the popularity of that theory, to make much sense of it. It's not, by any means, a clear account of what truth means, even in science. But it's very popular, and people are working to try and explain in what way a word can correspond to a collection of molecules. And these are very serious problems. When we come to a different domain, our ideas about what makes a proposition true ought to be sensitive to the requirements of that domain. We couldn't use a correspondence theory of truth for ethics or morality because there is nothing to correspond to. I have some fun in this book because I talk about morons, meaning moral particles that act the way electrons and protons might. And it is a kind of joke that I keep repeating probably too often, but you couldn't make sense of a correspondence theory of morality without making the mistake that Hume warned us against by saying there's no description of facts from which you can extract a moral proposition. So we need a notion of, once we accept that truth is an interpretive concept, we need an interpretation of truth that fits the way we conceive of morality. And I believe that the idea of interpretation gives us a sense of truth. As Bernard Williams said in his book, Truth and Truthfulness, when we come to offer a theory of truth, we shouldn't think of truth alone. We should think of the family of virtues into which truth fits. So we think of truthfulness, sincerity, accuracy, responsibility, and the other nest of words. We try to understand truth as part of an entire family of concepts of which we have to make sense. We have to interpret each in the light of the others. And when we do that, yes, we have a theory of truth which is not on the list of a metaphysics or epistemological text. There you see correspondence, coherence. You see another, much more popular theory of truth, which is called minimalist or detachability theory of truth. These are all candidates for a theory of truth. They may or may not suit different enterprises. They don't, any of them, suit morality. we need to do a fresh interpretation of truth. If we take the alternative and say, truth, because none of these accounts of truth that make sense in science, or might make sense in science, don't fit morality, there is no truth in morality. That's bad, in my opinion, that's bad philosophy. You have to look at the enterprises of morality, enterprises in which truth figures centrally, and try and interpret the idea to see if you can. So I accept your suggestion that the account of truth I develop is not recognizable in the list of familiar understandings of truth. That doesn't rule it out.
Andrés Robles.
I'd like to cash in on your the opportunity you're giving us to go back to your talk of yesterday, if I may. If I remember well, you argue that your talk was given in the, I would say, in the spirit of Grotius, that there is a Grotian ring to it. But I'm not quite sure whether that's what you really mean in the following sense. Perhaps my question would be what you mean by Grotian in this sense, and by the spirit of Grotius. And I'd like to add two short points. The first one is, when it comes to the nature of international law, I think Grotius is actually well known for defending a positivist reading of the nature of natural law, of international law, I'm sorry. He claims that the source of international law is actually conventional. And on the other hand, when it comes to the content of international law, Grotius is also, I think, well known for defending a sovereign system of states, which, of course, they do apply principles of natural law or morality, but perhaps we are wrong in reading Grotius in this sense. Actually, it is Hobbes the one who claims that when it comes to the nature of international law, it's nothing but principles of natural law. And by that, he's also taken to claim that there is no international law. It's quite the contrary, but a different ballgame altogether. So, what do you mean by the spirit of Grotius and the Grotian ring to your position on the nature of international law and the content of international law?
Thank you very much. In some famous Humphrey Bogart film, and I've forgotten which one or which character says it, but someone says, I think, to the policeman, but you have arrested all the wrong people. And he says with a smile, I was misinformed. And that may be the explanation of my account of Grotius. Perhaps I was misinformed. I have colleagues at NYU, international lawyers, who described Grotius to me in that terms that I used, and gave me various things to read. And from those, I took the view that Grotius thought that international law begins in the requirements of states, that it is not just a matter of what states consent to. But I have to say, I am not wedded to that interpretation. I appeal to Grotius in an attempt to say that my theories are not so original after all. They were once popular, and perhaps I'm wrong in that. I don't think so, because my memory of what I read about Grotius is not what you summarize. But if it is, I correct by withdrawing the name Grotius and keeping everything else the same.
Gracias, Héctor.
Professor, I have a question concerning part 1 of Justice for Hedgehogs.
Yes.
On page 44, you say that Hume's principle is both a principle of moral epistemology and that it and that it is obviously true for you. Yes. Now, I think that there is an inconsistency in your assertion that Hume's principle is a principle of moral epistemology, because after all, the whole argument in part 1 of your book is that there are no principles of moral epistemology or principles of external metaethics. So I had to conclude that when you say that Hume's principle is a principle of moral epistemology, you are referring to other people's opinions. So it seems to me that in your own viewpoint, you should say that Hume's principle is a normative principle or a principle of morality. Now, if it is a principle of morality and in some way it comes from an interpretation of our moral practice, then it's obvious to me that it is not obviously true. Because, for instance, it's not obvious that you cannot take the fact that you are watching a child starving as a self-sufficient case for the moral claim that's something bad and that you should do something about that. So as a normative principle, it's very controversial. Now, and I finish, if you really abandon the claim, the general claim that there are no principles of moral epistemology, and after all, there is one external second-order question, which is precisely Hume's principle, then in that case, it's not obvious to me either that the principle justifies your claim about the independence of morality from philosophical argument in moral philosophy. And the case seems to be very clear, because even if Hume said, which is also very controversial, that you cannot infer an odd statement from an is statement, or at least that you should give an explanation why you are allowed to draw that conclusion, it's obvious and evident to me that he never talked about permissions, let alone moral permissions. So it seems very evident at the same time that you can take a factual claim as a case for rejecting an odd claim, which means as a case for grounding a permission. Now, after all, this is very, very widely accepted in moral philosophy. For instance, Kant said that the fact that some action is factually impossible, for instance, a doctor cannot, for factual reasons, save a patient's life, then if that's impossible, factually impossible, then you have a case for rejecting the odd, which means that, after all, it is, although very sadly, permitted for a doctor not to save the patient because that's factually impossible. Now, if you, I finish with this, if you take the different principle that the factual claim can reject odds and found permissions, then, after all, external skepticism seems to be reasonable. And that's why I think that there is something which seems to me wrong. And either way, I would like some clarification on that. Thanks.
That was what we call a very meaty question, a lot in it. I'll start by saying that I didn't mean to say there's no such thing as moral epistemology. On the contrary, in a chapter devoted to moral responsibility, I say, I think, that moral responsibility is a moral epistemology. This goes back to the question about truth. That is, if you take epistemology to be the study of when we are entitled to claim knowledge or justified belief, then I say the scientific epistemology fits only science. For morality, we need a moral epistemology. A moral epistemology is a theory of moral responsibility, a theory of what you ought to have done by way of reflection before you should treat yourself as justified in holding a moral position. I believe that's an epistemology. It's just not a scientific epistemology. As we want to have a different conception of truth for different domains, so we should have a different conception of epistemology. So I plead guilty to saying Hume's principle is a piece of moral epistemology, I also accept what you then said, that it's a moral principle, because every theory of moral responsibility is itself rests on a moral theory. You can't get out of morality. That's what I mean by the independence of morality. That is, for many people, an objection. You know, there's no way to get outside of morality to test it from the outside. No, I don't think there is. There is incidentally no way to get outside mathematics to test it from the outside, and so forth. So on the question of classification, I don't think what I say about Hume's principle is in any way inconsistent with the rest of what I say, though you may continue to think otherwise. Now, on the question of the substance of Hume's principle, you say you see a baby being tortured, and you say, I have a moral that is obviously wrong, and I have a moral responsibility to try to stop it. Now, the classical explanation of that, of course, that's a phenomenological fact. That is just how you respond. You don't then say, now let me see whether there's a moral premise of the form, if someone is suffering and I can do something about it. As Bernard Williams once said in a different context, if you thought you should check the major premise, you have one thought too many. The phenomenology is absolutely as you say, but the reconstruction of it must presuppose a more general moral theory, innate in all of us, probably hardwired into us, but still a major premise. And the way you can test that is to imagine some real monster. The world has known real monsters in the last century. Imagine a real monster who confronts this situation and says to you, no, I don't accept the implication. There's a baby, it's screaming, how amusing. And you say to him, but that's intolerable. And he says to you, why? And I believe you would be tempted at this point to propose a more general moral theory about the nature of evil. I would think. In any event, I don't believe, I think Hume is right, I don't believe that you could make a construction that didn't assume that. Here's another way to put the point. Baby is crying, you respond, you feel you have to respond immediately, that it's a moral imperative. But you find, on reflection, that you don't believe any general principle that says you ought to respond to harm in front of you. No more general moral claim. You have to correct your initial impulse. All right, that's enough on Hume's principle. Now, on permissions, what is the status? Kant said, ought implies can. And you gave a good illustration of Kant's principle. What is the status? What kind of a judgment is the judgment ought implies can? It's not a conceptual claim. It's not analytically true. It's a moral judgment. And it's a moral judgment that many people over time have rejected. Oedipus could not have known that the man he slayed at the crossroads was his own father. Still, he put his own eyes out of a sense of moral guilt. He did not say to the Thebans, "Ought implies can, so I'm guiltless." We do have a Kantian, we do, most of us, or a lot, not even entirely, but most of us, most of the time, accept the Kantian view. We don't feel guilt for something. We don't think we should feel guilt when we couldn't have done anything about it. That is not a universally held view. It's certainly a moral view. The bus, here's another example. The bus driver driving a school bus, through no fault of his own, the brakes fail and several children are killed. He spends the rest of his life bearing a sense of regret merging into guilt, though he couldn't have done anything about it. That's also part of the phenomenology. So I think that ought implies can is a moral principle. It's a general moral principle. It helps confirm Hume's law, because we rely on it to validate more specific moral claims, like the bus driver shouldn't feel guilty. If we're correct in our feelings, it is the correctness of our feelings. It's the truth of what these feelings reflect. Moral, because we have to distinguish indeterminacy from uncertainty, because skepticism or subjectivism is not a default. If in my best judgment, torturing prisoners in Guantanamo Bay is wrong, that is, I think about it, and my best judgment is that it's wrong to do what the United States government did. If I'm right, then it's wrong, then it was wrong. But it's not wrong because I made the judgment. It's wrong if my judgment is correct. So it's not just my feelings that make it wrong. It's the case, the adequacy of the argument that I have that makes it wrong. Skepticism won't, I think, I want to repeat that I regard one of the main claims of part one of the book to answer the question or the suggestion that if we can't prove something to the satisfaction of everyone, then we should be skeptical about it and say, well, it's just a matter of my feelings. I don't think that's a defensible philosophical position. It's a very popular philosophical position, so I hope people read part one of my book.
Ezequiel. Después Tamara. Tamara, Ezequiel.
So, I apologize if my question is too philosophical or technical or something, but I wanted to know if you have any idea, if you have given some thought of what kind of physical story fits with your account, because I think one of the main problems of everyone who tries to be, I think you should choose some variety of non-reductive physicalism, I'm pretty sure.
I'm sorry, I'm having trouble understanding.
Oh, I'm talking too fast. I'd like to know what kind of physicalist story, I mean philosophically speaking, you embrace or you think fits with your theory, because you reject supervenience in the book, right? You seem to reject it, Davidsonian supervenience. And I didn't find much about Putnam either, just in the footnotes. I think you reject that too. And you also reject intuitionism, and you just spoke against some sort of super reductive emotivism or something, like in the last answer. So have you given some thought about that? Because it's a problem. I mean, if you are going to defend the independence of value or something like that, how are you going to make that fit?
With physicalism.
With physicalism.
Yes, thank you. I think I understand. It fits with physicalism as a separate domain that is not at all physicalist. Science, let's take, we abbreviate and we suppose that physics is about the physical world and psychology is about the mental world. I do not believe that we can reduce the mental world to the physical world. I am not a believer in that reduction. I don't believe that we can reduce the mathematical world to the physical. I am not a believer in nominalism in mathematics. And now to your point, I don't believe we can reduce value to physics. I think we need to use another technical word. I probably get into trouble as with epistemology. But if we want an ontology, a general theory of what there is, of what exists, then we have to recognize different domains. And what exists includes atoms, ideas, numbers, and moral obligations. These are all things that exist. They don't exist in the same way. You can't restate a mathematical proposition as one about molecules, but they all exist. Our ontology must be driven by our conviction, not the other way around. We can't say we are physicalists, therefore we have to fit everything into physics. There was a time in Germany in the 19th century when it went the other way. Ideas are the only real thing, and therefore we have to fit the physical world into the psychological world. I don't see why any of that is necessary. I think we first decide what is true, and then we see how we should arrange our ontology to match our convictions.
Ezequiel, and then...
Professor Dworkin, I have a question about what you call ethical independence. On the one hand, you claim that a law can violate ethical independence in virtue of the foundational character of the decisions that this law inhabits.
Yes.
On the other hand, you claim that if the government obligates people to wear seatbelts, that government doesn't violate ethical independence because you say seatbelt convictions are not foundational. However, as you claim in the book, it is empirically possible that there is a person who thinks that a life that runs danger or courts danger is more attractive. You admit that, but you continue claiming that seatbelt convictions are not foundational. So I wonder what the definition of foundational is. Most of people don't have seatbelt convictions, but the definition of foundational cannot depend on the majority opinion. Maybe foundational means relevant, but in that case, that definition arbitrarily excludes certain convictions, such as seatbelt convictions.
Yeah. Thank you. It's a very interesting question. I probably did not take enough care to define foundational, but the idea I have in mind is that people who have a self-conscious sense of personality, a sense of how they want their lives to go, what is important to those lives. When we reconceive people's convictions about how to live in that way, then we can say some things are more important than others to that project. There are convictions about religion, for example, that really are fundamental to, you can't imagine not living in accordance with that. Now, other views are peripheral. They are ephemeral. They're just something at the moment, but they don't fit into a more general scheme. I agree with you, and as I think I did say it in the book, that for some people, a life of daredevil is the only fulfilling life. They jump out of airplanes with parachutes. They climb very dangerous mountains where you have to hit nails into the mountain in order to get up or down. And there are people perhaps who regard putting on a seatbelt as self-betrayal. So the question is, what should the response be to these people? There are 2 points I think one might make. The first is that these people are so few that equal concern for them does not require the expense that would be involved in having a general seatbelt law, but exemptions for them. Can you imagine a trial in which they were invited to testify as to their daredevil quality? It would just be unreasonable to expect government to try and administer a program like that. The second point to make, which I think is necessary, is that people who are injured in automobile accidents injure everyone in the community. The external cost, both to the economy, in their absence from the workplace, and worse, in the medical expenses that are incurred taking care of them, particularly in a country like this one, in which medical care is paid for out of the general tax revenues. It would be wrong to say the government doesn't have to rely on what I take to be a forbidden justification. It doesn't have to say your conception of a good life is wrong. It has only to say it would be unfair to the community to ask the community to bear the cost of this particular very unusual preference of yours. So I think it passes the test of ethical independence.
Just a few more.
Oh, yeah, whenever you want.
Professor, if you don't mind, I'd like to come back to yesterday's conference and make sure I understood you correctly on one point.
Yes.
You talked about the duty of the state to protect its own legitimacy. Am I correct?
Yes.
And you also talked about the duty to litigate.
Yes.
Okay. My question is, what in your opinion grounds this duty? And my second question is, do you see a connection or a nexus with the so-called duty or responsibility of the state to protect? Thank you.
Yes, thank you. What I tried to suggest yesterday begins in the idea that it is a central concern, should be a central concern, of people who exercise coercive power, police, guns, armies, over other people, to protect their moral title to do so. Now, of course, anarchists think government is always immoral because nothing can justify the use of force, particularly collective force, against an individual. So they reject most of government. But if you don't accept that view, and government generally, obviously, does not accept that view, then a government should try always to improve its moral title to govern. If it believes that it is shown to the government that it is violating human rights, for example, by discriminating against one race or group, then it has a duty flowing from the fact that it exercises collective power to improve its right, to remove a stain on its legitimacy. So that is a background assumption that I make. It's a general assumption of political morality. Now, the key point in the argument I offered is that the legitimacy of each particular state depends in part on the international understandings that bestow rights to govern on particular territory and limit the power of government to address issues on other territories. We have that understanding. We probably, the only way we could give up that international arrangement is by moving to one world government, which is not going to happen, can't happen. Therefore, if we identify a problem touching legitimacy, a stain on legitimacy inherent in the international understanding, then we, each nation, have a duty to mitigate that so far as we can, to take steps, just as we have a duty to do it domestically by stopping discrimination, so we have a duty internationally to improve the international system, to remove the difficulty it poses on our own domestic legitimacy. And that seems to me to be the beginning, it's only the beginning of an explanation of the need for and the character of international law. International law is what gets created when states recognize their duty to mitigate the injury that the international understanding, the Westphalian system, poses to people. Now, one of the threats, I mentioned this, but your question invites me to say more. One of the threats to legitimacy created by the international system is this. People the world over feel a moral responsibility of rescue. If we see people in the Sudan or in Libya or in 100 other places are the victims of very serious denials of human rights, and they suffer. They're diseased, they're hungry. A tsunami takes place, and people are dying in great masses, and their own government is unable to feed them, get food to them, as in Asia. We feel we have a moral responsibility to help, but we can't, because the international understanding allows the government of Burma to say, we refuse to accept any food sent from abroad. We won't distribute it. We are immune from your help. Now, I regard that as a problem, and international law ought to respond to it. The doctrine that you mentioned, sometimes called R2P, responsibility to protect, was endorsed by a convention in Canada some years ago, and then endorsed in principle around the world, including in a meeting of the United Nations Committee. That is an example of what I meant yesterday by the impact of salience. Once that has happened, then it focuses the general amorphous duty to mitigate in a particular direction. So we ought to respond in the spirit of the convention called R2P. And the right way to respond is to accept that the General Assembly of the United Nations, by majority vote, can authorize protection of people in other countries. I'm sorry, it's a long-winded answer, but that's the...
Quedan poquitos minutos. Paula, atrás. Two more questions.
Yes, whatever you want. I'm not.
Hi. You want to differentiate two different questions, what a law is and what law should be. And you say also that these different questions can receive different answers. But what I don't understand very well, because according to your account of law, an answer to what law is presupposes an answer to what law should be. That is.
Thank you. Let me try to answer you this way. What the law is and what the law should be are both moral questions, but there are different kinds of moral questions. I think of law as based in interpretation of a nation's political practices and past decisions. It might very well be that it is impossible to interpret this tradition in what you and I would think is the best moral light. We think, I'll give you a perhaps rather complex example. I think that the law in the United States should be that each school child gets the benefit of the same amount of money spent on his or her education. That is what the law should be, in my view. But it's absolutely plain, given various decisions by the Supreme Court, that I could not interpret, even trying to make the best interpretation, I could not interpret the law of the United States as including that requirement. moral question, what should the law be, is open-ended. It doesn't say anything about which institution would have the responsibility to create the law, to make it that way. What the law is, if I say something is the law, then I say that this is a right which people are entitled to have enforced right now on their demand through the use of the state's coercive power. Now, the moral question, what should the law be in an ideal world, is to me obviously different from the question, what are people entitled to have enforced right here and now through the coercive power of government? That's the difference between what the law is and what the law should be.
Yes, may I ask you a question myself? No, about the topic, I mean, I'm sorry because I will change the subject completely, but I wanted to ask you about something you touch just a little bit in your book, which is, I think, very relevant for countries like Argentina or Brazil, which has to do with the connection between responsibility and inequality. So if you, I mean, because you say a little in a couple of paragraphs, but if you could elaborate just a little bit more on, how, I mean, to help us to think how to think about crime committed by people coming from a rotten social background. So I guess your view is that in some occasions we may discount their responsibility in view of the injustices they suffer. I don't know if that's correct, but that's a very important point. So it's not assuming a position like Judge Bazelon assumed at one point, saying that, well, in a way, touching on the capacity of these people. But you want to say we have to take into account the injustice they are suffering. So if you could elaborate a little bit on that, and also in the face of some of these injustices, just to take an example you knew when you were in Brazil, imagining the occupation of empty state land by an extremely disadvantaged group. As an interpretation of law, you would call that a violation of law in the first place. Yeah. So a reflection on that connection, responsibility.
Thank you. I love questions that say, I would like you to talk for a while, but the problem is you have to stop me. What I meant in the discussion that you have in mind was governed by the general topic of that chapter. Yeah. And the chapter is a chapter on the old philosophical problem of free will. I was anxious first to say that people who come from deprived backgrounds and are more likely to be antisocial or to be thieves do not suffer from lack of free will. It is sometimes argued that they do. There was an infamous case in Florida in which somebody was accused of, I think it was murder, and his defense was, I didn't have free will because my mind was taken over by watching television programs in which murders were regularly committed. So my free will was taken over because I was programmed by these television programs. First thing I wanted to say is that is an extremely bad argument. Yeah. We do not lose free will because we grow up or live in circumstances in which our motives are different and our motives arise out of injustice. People who come from very deprived backgrounds have beliefs about what they're entitled to and have needs and have motives that people from middle-class backgrounds do not have. But that's not a problem of their free will. They're free, as we are, or as anybody, to assess the situation and act in accordance. Is that the end of the story? I want to say no, that's not the end of the story. We have to be conscious when we ask how responsible they are, not just of whether they had free will, of whether they were automatons directed by terrible motives. We have to take into account the fact that they had different needs and motives. And we have to accept that in an unjust society, we share part of the blame for the differences. So they're not insane, they don't lack free will, but they are entitled to the benefit, often of reduced sentences, and sometimes, in very rare cases, of acquittal, on the ground that when you distribute fault, the fault for what they did is in good part the fault of the economic system, the social system that we created. Clarence, I don't know if anyone here has ever heard of an American lawyer, long dead, called Clarence Darrow. He was the most famous criminal lawyer in America. And he was hired to defend two boys, very rich boys in Chicago, who kidnapped another boy and killed him for fun. They had read Nietzsche, they said, and Nietzsche inspired them. And Clarence Darrow made the famous argument that even in the case of these rich boys, society should assume part of the blame because the unjust economic system allowed these boys such privileged backgrounds as to make them think that they were supermen. They were Nietzschean supermen. Now, I always think of that argument as a kind of reverse coin of the normal kind of argument that disavows. And I think Darrow's argument was wrong. But that's the kind of argument we should be making, nothing to do with free will or insanity.
Yeah. Well, last question we get to Marcelo.
These last weeks, the debate on abortion started in the Argentine Congress. I want to ask you if you please could try to illuminate our discussion. So if you could briefly tell us your philosophical take on the issue, but also and especially I would ask you to take into account the experience of the last 40 years of America. How can that experience of what happened since Roe versus Wade to now can help us to better deal with this controversial problem?
Good. I'm happy for the opportunity to speak on a contemporary political issue. In my view, the question of abortion has got to involve two stages of thinking. The first stage is the question whether an early fetus is a person with rights of its own, a person with interests and rights of its own. I don't think, sometimes it's said, government shouldn't make that decision. It's a religious decision, it's a metaphysical decision. Government should not make that decision. Now, in my opinion, government must make that decision. The government may not take the position that in the United States, that states can decide whether a fetus has interests and rights of its own. The question is whether a fetus is a constitutional person. That is somebody who is the Supreme Court, the courts, the legislature have a moral duty to protect from murder. I don't think that the argument that an early fetus is a person with rights, doesn't matter whether we call it a person, the key question is whether we should recognize it as having a right to live. And I think the answer to that question must be no, because a creature doesn't have interests before it has sentience. That is, before it can feel and feel pain. According to some theories, a creature doesn't have interest until it has a kind of self-consciousness, which comes later. That's a difficult theory because of its implication for animals who never have more than, who never have, so we think, self-consciousness. But at least in the case of sentience, that is the ability to feel pain, I think it extremely implausible, and so did the Supreme Court, extremely implausible to suppose that something that can't feel, that has no sense of itself, even at the level of feeling pain, has interests. We may have an interest in it, but it has no interest of its own. And obviously the question can be debated back and forth for longer, but I simply report my own view on this question. It was the view of the Supreme Court. It is also the view, I must say, of many of the opponents of abortion in the United States, because they argue that the question of whether abortion should be prohibited is a question best left to democratic decision. If a fetus is a person with interests and rights of its own, you can't leave that question to democratic decision any more than you can leave the question of whether Jews or Muslims have rights and interests of their own. Can't have a situation where a majority could say no. I add that only to say that not many people actually think that a fetus has rights and interests. Polls, even among Catholics, say that most Catholics think that a pregnancy that begins in a rape should be permitted to be terminated. And of course, that would be wrong if a fetus was a person, a constitutional person. I should say that there are people who do hold the view, they're a small number, but they do hold the view that even a woman who's raped, or even a woman who will die if the pregnancy is continued, has no right to an abortion, but they're very few. Now, the question is, which I regard as the interesting question, if you believe that, is the debate over? Is that the end of the story? And in the book, Life's Dominion, I argue that that is not the end of the story. Because even if a fetus is not a person with its own rights, it is something that we might regard as something of enormous value. Indeed, I would go so far as to say that human life at any stage should be regarded as sacred. So I can very well understand the view, indeed I hold the view, that a woman who has an abortion for frivolous reasons, there are stories of women who have abortion because they had a trip planned to Europe and they don't want the trip to Europe spoiled by their pregnancy. I think they fail to understand something very important. Their values are entirely wrong, in my view. I take the opposite view about a teenage mother, a 13 or 14-year-old, living in great poverty, no prospect of being economically able to raise no identifiable or at least identified father. It seems to me that respect for life at that point switches to a concern for her life. I do think, therefore, that there are issues about value that remain even after we say a fetus has no rights of its own. There are good ways to respect human life and bad ways. Now, the third stage. Who gets to make that decision? Earlier in our discussion today, someone mentioned the right to ethical independence. I think the right to ethical independence, which traces back to my account of dignity, dignity requires that we make decisions that reflect our view of what's important about human life. Issues that don't involve the rights of others, but do involve questions of respect. Questions about whether we should lead our lives, the only ones we have, simply trying to acquire money, which is a rotten version of what human life is for. I think those have to be allowed, even when we know they're going to make mistakes. Those decisions have got to be allowed to be made by the person whose life is in question. And now you see the conclusion I draw. The abortion decision is a foundational decision that reflects a person's sense of how and why human life is important. People must be free to make bad decisions. In the case of the woman planning her trip to Europe, very bad decisions. Those belong to the individual. It is not to the collective to make those decisions. Now, finally, American experience. We have had, since 1973, a lot of experience. It's gone in two ways. First, the question has not gone away. Decided by, I think, a 7-2 decision by the Supreme Court, in 1973, many people thought once the court had spoken, people would accept the decision. Not at all. There is continuing pressure. The continuing pressure calls for legislation state by state. There is now a great temptation all around the country of the states where the anti-abortion sentiment is most lively to adopt statutes challenging the decision of the Supreme Court, hoping that the Supreme Court, which is now much more conservative, very, in fact, right-wing, hoping that the Supreme Court will finally reverse Roe and Wade. So I tell you this history to suggest that the issue, people have not accepted the decision of the Supreme Court as final. Neither have the justices. 3 of them keep saying, we wait for a chance. I hope it's only 3. There's another side to the story. Abortions have decreased in the United States steadily, the number of abortions. And that is because sex education, another thing that conservatives dislike, has become much more sophisticated and general. The freedom to have an abortion has come along with responsibility. Many fewer teenage pregnancies than there used to be. And I believe these are connected phenomena. A general shift. If we had a national vote on abortion, the present law would be confirmed by and large. The general opinion in America, like the general opinion about gay marriage and various other issues, is shifting demographically, because young people have different attitudes, and as they grow older, there are more of them. But in the case of contraception and abortion, the shift has been dramatic. So if Roe and Wade was repealed and the states were free, all the red states would ban abortion, and all the blue states, I shouldn't do this in terms of color, all the states that border the Atlantic and Pacific Ocean would reject any prohibition of abortion, and a great many of the states in between would accept it. But all the polls indicate that the general opinion in the country as a whole is permissive. Now comes the question that I think puzzle a great many political scientists. Would it therefore have been better for the Supreme Court not to make its decision in 1973, but to let the demography and to let the increased sophistication be reflected in state legislatures so that democracy would have produced the right answer? Many people who favor abortion rights think that would have been better. I don't, for 2 reasons. First, well, I suppose it's only one. I worry about all the women from 1973 until some future date, which will depend upon the states, all the women who would not have had enough money to take themselves to a coastal state. I said that abortions are down as a total number. What is also down, obviously, are deaths from illegal abortions. That was a very serious problem in the ghettos and pockets of poverty. Teenage girls couldn't face being pregnant. Their friends knew where to go, and some of them ended up dead on an operating table or 2 weeks later of sepsis. I'm always troubled by the argument you should let things take their course. Better to have them democratically settled over the long term. This is still the American story because, of course, you have one legislature. But I don't like those stories because it treats individuals, in this case poor women, as pawns, expendable for the sake of a purer form of democratic theory. In spite of the horrors of the present Supreme Court, I still believe in it. There are some issues that are legal issues because they're issues about the rights of a minority at risk, not to be trusted to the majority in power.
Brevísimos comentarios. Primero, 1000 perdones para todos aquellos que levantaron la mano y no tuvimos tiempo, no les cedí la palabra, así que 1000 perdones a ellos. Muchísimas gracias a la decana Mónica Pinto y a la universidad por hacer posible este increíble acto, y en particular un agradecimiento enorme al profesor Dworkin por su compromiso político, su compromiso público, su compromiso académico y la lección enorme de generosidad intelectual que nos ha dado. Thanks so much, Professor.
Thank you.